marriage registered in the county of Lake, state of Illinois?
Yes.
Are you 48 years of age?
Yes.
And is Edwin 56?
Yes.
Were 3 children born to you and Edwin during the course of your marriage?
Yes.
Were 2 of those children emancipated?
Yes.
And you have 1 minor child, a daughter who is 16 years of age, is that correct?
Yes.
Have you and Edwin agreed that you are each fit and proper persons to share the allocation of parental rights and responsibilities for your minor daughter?
Yes.
And do you know of any litigation that's pending relating to you and Edwin's marriage or your child in any other state?
No.
Have irreconcilable differences caused an irretrievable breakdown of your marriage?
Yes.
Have efforts at reconciliation failed?
Yes.
Have you and Edwin been separated for a period of not less than 6 months?
Yes.
Have you and Edwin entered into a allocation, judgment, and parenting time plan?
Yes.
And do you agree to be bound by those terms?
Yes.
And have you and Edwin in that agreement provided for a review clause annually?
Yes.
And have you agreed to go to mediation if you have any parenting issues?
Yes.
Is Edwin going to pay you the sum of $135 per week as and for child support?
Yes.
And is the $135 a week a slight deviation upward from the child support that was $122.31 per week?
Yes.
And that was an agreement between you and Edwin, is that correct?
Yes.
Have you and Edwin agreed to share extracurricular, school, and health expenses on a 50-50 basis for your daughter?
Yes.
And Edwin has agreed to maintain his life insurance policy through work, is that correct?
Yes.
Have you and Edwin separated all of your personal property?
Yes.
Have you and Edwin agreed to separate your bank account and each of you keep each bank account in your own name?
Yes.
Will Edwin be receiving the Ford Explorer, Dodge Ram, and a motorcycle?
Yes.
And will you be receiving your Mercury Mariner?
Yes.
Are you waiving your right to from Edwin to maintenance, meaning that you cannot have maintenance paid to you by Edwin as part of this case?
Yes.
And do you understand that that means that you can't come into this court or any court now or in the future and ask for maintenance from Edwin?
Yes.
Similarly, Edwin is waiving his right to maintenance from you, is that correct?
Yes.
Are you and Edwin each going to keep your own retirement accounts?
Yes.
Are you and Edwin each going to keep the debt in your own names?
Yes.
Are you going to be claiming your minor child on as an exemption for tax purposes?
Yes.
Is Edwin going to be responsible for his fees associated with this litigation?
Yes.
Are you asking the court to resume the use of your maiden name White?
Yes.
Did you and Edwin come to the terms of this judgment for dissolution of marriage together?
Yes.
And that was by agreement, correct?
Correct. Yes.
And did you and Edwin both sign the judgment for dissolution of marriage that the judge is viewing at my office together?
Yes.
And if, have I given you any legal advice during this case?
No.
I have no further questions, Judge.
Thank you. The court finds it has subject matter jurisdiction and personal jurisdiction over the parties. They were married on July 23rd, 2002 in Waukegan, Lake County, Illinois. They've been separated for at least 6 months. At least one of them has lived in Lake County for 90 days prior to filing the petition. There were 3 children born to their relationship. One is still a minor, initials VG, who's 16 years old. No other children were born or adopted to their relationship. Ms. Garcia is not pregnant. The court finds it has jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act. The court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage. And efforts at reconciliation would be impracticable and not in the best interest of the family. The court finds the parties have entered into a written marital settlement agreement, which the court has reviewed. The court finds the property settlement is not unconscionable. The division of marital property and debt and non-marital property is fair and equitable to memorialize the marital settlement agreement. The court finds the parties agree to waive any claim of maintenance as to the other. That waiver is not unconscionable. The court finds the parenting plan of the parties serves the best interest of the minor child after considering all the required statutory factors. That parenting plan contains the necessary dispute resolution provisions and review provisions. The court finds that parents will be able to cooperate with carrying out their significant decision-making responsibilities in the child's best interest after considering all required statutory factors. The court finds the parenting time arrangements of the parties serves the best interest of the minor child after considering all required statutory factors. Child support is appropriate in the case. The court accepts the slight deviation. Mr. Garcia shall pay Ms. Garcia $135 a week for child support. Ms. Garcia may, but is not required, presume use of her maiden name of White, common spelling, if and when she so chooses. Anything else before I finalize this?
That's everything, Judge.
And Ms. Garcia, I'm now finalizing the judgment for dissolution of marriage. That's on the same terms that you've worked out, and that means that this will be completed now. The parties will be sent a copy of the completed documents. Good luck.
Thank you, Your Honor.
Thank you, Ms. Rawls.
Thank you, Your Honor.
You. And again, anybody have, we're ready on a number of prove-ups. I know that. Anybody have anything that's not going to be a prove-up today? And yeah, and Mr. Lenzicki, I think you and Ms. McCollum have an agreed upon date. Is that right?
We do, Judge.
And what date's that?
We were looking at July 31st, Your Honor, to try to prove this matter up again. It's called Schenck.
Okay, Schenck will be continued to July 31, 8:45. See you then.
Thank you, sir. Have a good day, sir. Bye-bye.
Thanks. And I think the parties were ready on Michael and Olga Paul. Is that correct?
Yes, Judge, that's accurate.
And let's see if Mr. Eric.
I am here, Judge.
Thank you. And
My client is under Odie, O-D-I-E, in the room, Judge.
I'm glad you told me that.
And my client, I believe, might be under Patricia using somebody else's laptop.
Okay, and we will, I just took the dictatorial privilege of giving them a full name to make sure I know
Thank you,
who
Judge.
I'm talking with. And if I can ask Mr. Odie Paul and Ms. Patricia Paul and Mr. Erickson, if you can please get the video rolling, since we'd like to see your smiling face too.
I am not sure how I start your video. Okay, I see a box here.
Probably bottom left. You may, where it says stop video. Make
I see it and I am in.
good.
Now it's Michael Paul. Patricia is just a wrinkle from someone else's computer.
Got it. I'm gonna do that. And thank you.
Apologize for that.
It's okay. I just want to make sure I know who everybody is. And I'm not looking at the wrong square.
Perfect.
Mr. Erickson, do you see the probably bottom left, the stop video accidentally?
You know, for some reason, my video is not coming up, but
And you don't happen to have that little piece of tape that's over the video, which believe me has happened in the last 2 years.
I don't think so.
Okay, because some of us are kind of creeped out by having one of those, so sometimes we always put a tape over.
Well,
So
I like not seeing me, and I'm ready to proceed if you're ready.
that's okay. If you're comfortable, I'm sure fine listening to just the voice. So I tell you what, I'm going to ask Mr. Michael Paul and Olga Paul to please raise your right hand. And do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you. Please lower your hand. And which of you is petitioner in this case?
Michael Paul.
Okay, then Mr. Erickson, you are welcome to make a record and proceed with testimony from Mr. Michael Paul.
Thank you. Judge, for the record, this is in re the marriage of Michael Paul and Olga Paul. It is 19D 1304. My name is Jeffrey Erickson of Erickson, Pohl and Carpenter on behalf of Michael Paul. Olga is also present, and she is present through her attorney, Michael Gauthier. Judge, you should have an executed marital settlement agreement in front of you. There is, the children are emancipated, so there are no parenting issues, and we are ready to proceed forward.
And the court has those documents. You are welcome to proceed with testimony.
Thank you. Michael, state your full name and give the court your address.
Michael James Paul, 4836 Eastwood Court, Waukegan, Illinois.
And you've resided here in the state of Illinois for a period of more than 90 days, correct?
I have.
You married your wife on December 26, 1975 in Fox Lake, Illinois. Is that correct?
That is correct.
And there were 2 children that were born. Both of them are emancipated, and your wife is not now pregnant. Is that correct?
Yes.
More specifically, Mr. Paul, there has been irreconcilable differences which have caused the irretrievable breakdown of your marriage. Is that correct?
It is.
And you believe that further efforts at reconciliation would be impracticable and not in the best interest of your family. Is that correct?
Correct.
Now, you and your wife have entered into a written property settlement agreement disposing of marital, non-marital issues of support and the like. Is that correct?
Yes.
You are asking, Mr. Paul, that your bonds of matrimony be dissolved. Is that correct?
Yes.
There is specific provisions in here referencing your marital home at 4836 Eastwood Court. Is that correct?
Yes.
And it's very specific about what is to happen when it's to be sold and what mortgages and encumbrances are to be paid from that. Is that correct?
Correct.
As well as there is a residence located at 13124 Birmingham Court, and that's going to become the property of your wife. Is that correct?
Yes, that's correct.
Now, there are automobiles which are addressed in this particular document. Is that correct?
Yes.
As well as your obligation to continue on the lease payment of a vehicle driven by your wife. Is that correct?
Correct.
Now, there are certain retirement assets contained in paragraph C, and those are your assets, and it sets forth as to how they shall be divided. Is that correct?
Yes.
As well as certain accounts attributable to your wife. Is that correct?
Yes.
There were certain life insurance policies which have been addressed with you and your wife in advance of this prove up. Is that correct?
That's correct.
Now, you have gone ahead and filed a general federal and state income tax return for 2019. And basically, the refund has been divided. Is that correct?
I have yet to receive it. I should have it this week. I spoke with my accountant yesterday.
All right. Now, there are certain listing under indebtedness as to what credit cards you will be responsible for and what credit cards and student loan your wife will be responsible for. Is that correct?
Yes,
You're each going to be responsible for your own attorney's fees and costs. Is that correct?
yes,
You've divided or will divide your marital furniture and furnishings, correct?
yes,
Today, you are waiving your right to receive what is referred to as maintenance from your wife. And you understand once you waive that, you would be forever precluded from coming into this court or any other court to say, I'd like to resume that right. Is that correct?
yes, that's correct.
And your wife is going to be barred from receiving any maintenance from you. Is that correct?
Yes,
Okay. Also, if your wife is so desires, she may resume her maiden name of Sherwin. That's spelled Sherwin. Is that correct?
correct.
You fully understand all of the terms and conditions of this settlement agreement.
I do.
And you are asking that in the event that Judge Simonian would see fit today to end your marriage, that he incorporate all of these terms and conditions into the
Yes.
final decree.
I do.
That's all the questions I have, Judge.
Thank you, Mr. Erickson. Mr. Gauthier, do you have any questions for petition?
I do not, Judge, no.
Thank you. And Mr. Gauthier, do you have any questions for Ms. Paul?
Briefly, Judge, yes.
You may.
Ma'am, please state your name.
Olga Denise Paul.
Ms. Paul, did you hear the questions that Mr. Erickson asked of your husband just now?
Yes,
If I asked you those same questions, would your answers be the same or substantially the same?
yes,
You also understand as part of this agreement, you are also waiving your right to maintenance formerly known as alimony, correct?
correct,
And you also understand that by doing so, you cannot come before this court or any other court and request maintenance formerly known as alimony, correct?
correct,
You believe that this agreement is fair and equitable and in the best interests of your family?
yes,
And it's true that no one forced or coerced you into signing these documents, correct?
correct.
I have no further questions of Ms. Paul, Judge.
Thank you. Mr. Erickson, do you have any, any questions for a respondent?
Just one, Judge. Ms. Paul, you have in fact made a full and complete disclosure of all of your income as well as your assets, and they are contained within the four corners of this document. Is that correct?
Correct.
That's all I have, Judge. Thank you.
Thank you. The court finds it is subject matter jurisdiction and personal jurisdiction over the parties. They were married on December 26, 1975 in Fox Lake County, Illinois. They've been separated for at least 6 months. At least one of them has lived in Lake County for 90 days prior to filing the petition. There were 2 children born to their relationship. Both are adults now. There's no minor children left to their relationship. Ms. Paul is not pregnant. The court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage, and efforts at reconciliation would be impracticable and not in the best interest of the family. The court finds the parties have entered into a written marital settlement agreement, which the court has reviewed. The court finds the property settlement is not unconscionable. The division of marital property and debt and non-marital property and debt. Fair and equitable and memorialized in marital settlement agreement. The court finds the parties agreed to waive any claim of maintenance as to the other. That waiver is not unconscionable. Respondent may, but is not required to resume the use of her maiden name of Sherwin, Sherwin, if and when she so chooses. Folks, anything else before the court finalizes the divorce in this case?
No,
Not
Judge.
on behalf of Mr. Paul, Judge, no.
And what I'm doing, Mr. and Ms. Paul, is I am now entering judgment for dissolution of marriage. And this completes the process of divorce for you. The clerk will be mailing a copy of the finished documents to the parties. My best wishes to each of you. Thank you.
Thank you, Judge.
Thank you very much, Judge. Have a nice day.
Sure.
Thank you, Mr. Gauthier.
Thanks, Jeff.
Bye, Michael. I'll talk to you later.
Okay, bye.
And next we have Padmani. And
Yes, Judge, we are here.
so, Padmani, and I've got this. Ms. Padmani, can you please raise your right hand for me, ma'am?
Yes,
And ma'am, do you swear to tell the truth, the whole truth, and nothing but the truth?
yes,
Please lower your hand, ma'am. Thank you. Ms. Fox, you are welcome to make a record and proceed with testimony.
Thank you, Your Honor. This case is in re the marriage of Niralabin Padmani and Rajnikant Padmani, case number 20D295. I'm Jennifer Fox with Dennis M. Gravel and Associates, appearing on behalf of the petitioner who is present today. The respondent is not present in court, but has filed his appearance pro se and wishes to proceed as a default matter. The grounds are reconcilable differences, and the petitioner has resided in Lake County, Illinois for more than 90 days. This court has jurisdiction over this matter. 2 children were born to the parties during the course of the marriage, and they have reached an oral property settlement, and I have tendered to you the judgment for dissolution of marriage as well as the allocation judgment.
The court does have those documents. Thank you. You're welcome to proceed with testimony.
Thank you, Your Honor. Could you please state your name for the record?
Nirali Ben Padmani.
And how long have you resided in the state of Illinois?
5 years.
Were you and your husband married on November 27th, 2013?
Yes,
And your marriage took place in the city of Surat in India, correct?
yes,
And you have filed a petition for dissolution of marriage in this matter?
yes,
And you and your husband have entered into an agreement regarding the distribution of your marital property, correct?
yes,
And that agreement's been reduced into writing and is contained in the judgment for dissolution of marriage?
yes,
Now, you and your husband have reviewed this document as well as the allocation document, correct?
yes,
And you and your husband signed both of these documents prior to today.
yes,
You've had a full opportunity to review these documents,
yes,
and you understand your rights and obligations under these documents.
yes,
Okay, now if the judge sees fit to grant you your dissolution of marriage today, you are asking the judge to incorporate your allocation judgment, correct?
yes,
And during the marriage, 2 children were born to you and your husband?
yes,
Are you currently pregnant?
no,
During the course of the marriage, were any other children born or adopted to you and your husband?
no, no,
During the course of the marriage, have irreconcilable differences and difficulties arisen?
sorry,
Has the marriage broken down?
yes,
Would future attempts at trying to reconcile be practicable?
yes, no,
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 that-
sorry,
Would you want to reconcile with your husband?
sorry,
Would you want to reconcile?
no,
Like,
no,
you wouldn't
no,
want to get
no,
back
no,
together?
no, no,
Thank you. The allocation judgment and parenting plan outlines joint decision-making, correct?
yes,
And it also outlines a parenting schedule for you and your husband.
yes,
Now, your minor child with the initials AR is going to temporarily reside in India with the grandparents, is that correct?
yes,
But upon AR's return to the United States, you will abide by the parenting plan in the allocation judgment, right?
yes,
Now, the allocation judgment provides a mediation provision in the case that you and your husband can't agree on something, correct?
yes,
And are you and your husband currently parenting under the allocation judgment schedule, parenting
Yes.
schedule?
yes,
And you believe that it's in the best interest of your children, that parenting schedule?
yes,
Now, because you and your husband's salaries are similar and due to your parenting time, the child support is being set at 0, correct?
yes,
But you and your husband will divide all child-related expenses on a 50-50 basis.
yes,
And you and your husband are each going to receive the property in your own possession, is that correct?
yes,
You're waiving your right to maintenance, or formerly known as alimony, correct?
yes,
And you understand you can't come back to this court or any other court to ask for maintenance at any time.
Yes.
And your husband is also waiving maintenance, correct?
Yes.
Now, if either you or your husband has a retirement plan, you'll retain that retirement plan in your own name,
Yes.
and you'll each be responsible for your own individual debts.
Yes.
And your judgment outlines how you will file taxes with the dependency credits for your children, correct?
Yes.
You are responsible for your own attorney's fees? Oh, can you hear me?
Please repeat the question.
You understand you're responsible for your attorney's fees? Ms. Padmani, can you hear me?
Yes.
Okay. All right. Do you consider this agreement to be fair and equitable?
Yes.
And you're asking the court to grant you the judgment for dissolution of marriage today,
Yes.
correct?
Yes. Yes.
Nothing further, Your Honor.
Thank you. The court finds it has subject matter jurisdiction and personal jurisdiction over the parties. They were married on November 27th, 2013 in the city of Surat, spelled S-U-R-A-T, in the country of India. They've been separated for at least 6 months. At least one of them has lived in Lake County, Illinois for 90 days before filing the petition. There were 2 children born to their relationship, each with the initials of AR. One is approximately 2 years old. The other is less than 1 year old. There's no other children born or adopted to their relationship. Ms. Padmani is not pregnant. The court finds it has jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act. The court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage, and efforts at reconciliation would be impracticable and not in the best interest of the family. The court finds the parties have entered into a written marital settlement agreement, which the court has reviewed. The court finds the property settlement is not unconscionable in the division of marital property and debt and non-marital property and debt. It's fair and equitable and memorialized in the marital settlement agreement. The court finds the parties have agreed to waive any claim of maintenance as to the other. That waiver is not unconscionable. The court finds the parenting plan of the parties serves the best interests of the minor children after considering all required statutory factors. That parenting plan contains the necessary dispute resolution provisions and review provisions. The court finds the parents will be able to cooperate in carrying out their significant decision-making responsibilities in the children's best interest after considering all required statutory factors. The court finds the parenting time arrangements of the parties serve the best interests of the minor children after considering all required statutory factors. The court understands why the child support is being set at 0 by agreement of the parties, including but not limited to the reasons of relatively similar incomes, and also the fact that one child is with each, shall we say, currently. And the court understands that, of course, that agreement may be changed on motion of either party. The court also allows that Ms. Padmani may, but is not required, to resume the use of her maiden name of Dhanani, D-H-A-N-A-N-I, if and when she so chooses. Is there anything else before the court finalizes the divorce in this case?
No.
Nothing further.
And what I'm doing now, Ms. Padmani, is I am finalizing the divorce, excuse me, that's on the same terms that you've worked out already. This completes the process of divorce, enters judgment for dissolution of marriage. You will be mailed a copy of these documents. Good luck to you, ma'am.
Okay. Thank you, my honor.
Thank you very much, ma'am.
Thank you, Your Honor.
Degner and Degner.
Good morning, Your Honor.
Good
Morning,
morning.
Your Honor.
Good morning. And
I believe the Degners are on here, or at least Jacob Degner should be on.
Hannah should be.
sure, and I know
Up there's Jacob. I see Jacob.
And Hannah's next to him, right?
Got it. And Ms. Hannah Degner, can you see everybody?
No, I
Okay.
can't see Jack or.
Here, let's see here. Now, question. You see on the bottom left, do you see where it says stop video? Do you
Yeah.
have, can you uncheck that box? It's kind of a weird phrase that they use.
Oh, there she is. Well, oh,
No. There you go. And Ms. Hannah Degner, can you hear us?
Yes,
Good. Okay. And Mr. Jacob Degner, I've seen you all along. Can you hear us too?
Yep.
Okay, good. I've got the documents from everybody. I'm going to ask Mr. Jacob Degner and Ms. Hannah Degner, please raise your right hand. Ms. Hannah Degner, can you hear me?
yes,
Okay, can you please raise your right hand, please?
yes, I am.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes,
Okay, please lower your hand. And I know there seems to be some issue on the video. I was just telling somebody a couple of cases ago, that happens to me at home sometimes, and God knows I don't know why. There's a freeze in the video here and there, but I'm not worried about it nearly as much as if you can hear us and you can see us, then at least we can get the job done here.
okay,
Okay, as long as you're comfortable, I sure am.
yes.
And which of the attorneys represents petitioner in this case?
I do, Your Honor.
Okay, Ms. Bowen, you are welcome to make a record and proceed with testimony.
Thank you, Judge. This is in re the marriage of Jacob Frank Degner and Hannah Joy Degner, case number 19D865. We are appearing on Zoom. Jacob is appearing in person and through his counsel, myself, Deanna Bowen. And Hannah Degner is appearing in person and through her counsel, Robin Vanderwood. There are 2 minor children. We have tendered to your honor our marital settlement agreements and our parenting agreement that has been executed by both parties.
Thank you. And I have all the documents. You're welcome to proceed with testimony.
Thank you. Jacob, please state your name for the record.
Jacob Degner.
Jacob, you lived in the state of Illinois for over 5 years.
Correct.
You were married to your wife on May 28, 2006.
Correct.
And that marriage took place in Evansville, Wisconsin.
Yes.
2 children were born to you and your wife during the course of the marriage.
Yes.
One was born in 2012 and the other in 2016.
Yes.
And irreconcilable differences have caused the irretrievable breakdown of your marriage.
Correct.
You made efforts to reconcile those differences.
Yes.
And despite your efforts, your marriage has failed.
Correct.
And you believe it is in the best interest of your family that you be granted a dissolution of your marriage.
Correct.
You have lived separate and apart in excess of 6 months.
Yes.
Your wife and you have entered into a marital settlement agreement.
Yes.
And we've had the opportunity to review this agreement.
Yes.
And you believe this agreement is fair and equitable.
Correct.
Pursuant to the agreement, you are waiving your right to seek maintenance from Hannah.
Yes.
And Hannah will be receiving maintenance from you.
Correct.
You have a marital residence.
Yes.
And there's a temporary order in place that will continue with until the marital residence is sold.
Correct.
Pursuant to that agreement, you will pay Hannah $650 every other week until the house is sold.
Correct.
And that is as and for maintenance.
Yes.
And then after the house is sold, you will pay $2,069 per month as and for maintenance.
Correct.
And this maintenance will be reviewable.
Yes.
And if Hannah files a petition to have it reviewed within 81 months from today's or from the last payment, let's try that. If Hannah files a petition to review within 81 months of the entry of the judgment, she has the right to have maintenance possibly extended.
I understand.
Each of you will be solely responsible for your health insurance after today's date.
Yes.
And until the children will reside primarily with Hannah.
Yes.
And then upon the sale of the marital residence, you will pay $1,366 per month as in for child support.
Correct.
Your income, you are entitled to bonuses occasionally.
Yes.
If you receive a bonus, you'll pay 10% of the gross of that bonus as in for additional child support.
Correct.
And the amount for child support is pursuant to the statutory guidelines if we impute $20,000 of income to Hannah.
Correct.
You will maintain medical insurance for the minor children.
Yes.
And uncovered medical expenses, we have different percentages, which will change beginning August 31st, 2021.
Right.
And it's spelled out in detail in our proposed judgment.
Right.
Additionally, we have additional expenses that each of you will contribute to for the minor children.
Yes.
And we have different percentages based upon dates that is also spelled out in detail in our marital settlement agreement.
Correct.
We are going to reserve each of your contributions towards college expenses.
Correct.
Each of you will maintain life insurance for the benefit of the minor children.
Yes.
You have filed 2019 tax returns already,
Correct.
and you have already distributed those amounts.
Yes.
I don't think this is in the judgment, but we have an agreement that if in the future we have any stimulus or any additional stimulus checks, that you would split those according to who's entitled to receive those.
Right.
We're going to split, so long as Hannah is not employed or not earning more than $20,000, you'll get both children as deductions for tax purposes.
Yep.
Upon Hannah earning more than $20,000, you will alternate those exemptions.
Yes.
You own the residence at 32433 North Forest Drive, Grays Lake, Illinois.
Yes.
Currently, that house is under contract,
Yes.
and we believe there is sufficient funds to pay all the debt off that is recorded against the property
Yes.
and all the selling cost.
Yeah.
And the net proceeds will be split 50-50 between you and Hannah.
Correct.
We have already distributed the personal property of the marriage.
Yes.
You'll keep everything in your possession, including your vehicle,
Yes.
and Hannah will keep what's in her possession, including her vehicle.
Correct.
You'll each keep your own bank accounts.
Yes.
There are no jointly held bank accounts.
Correct.
You'll each keep your own debt.
Correct.
Excluding the mortgage, there is no jointly held debt.
Correct.
I'm sorry, and could you please repeat the last question?
There is no jointly held debt.
Except this house, yes, that's correct.
Great. Each of you will be solely responsible for your attorney fees.
Correct.
You have contributed to 2 retirement accounts during the course of marriage through your employer.
Yes.
And Hannah will receive 50% of the marital portion of your AbbVie pension plan.
Correct.
And Hannah will receive $25,000 from the AbbVie retirement savings.
Correct.
And she'll receive that through a quadro, both of those.
Right.
You will receive your AbbVie stock and your E-Trade account.
Yes.
Hannah will receive her E-Trade account, her Capital One IRA, and her TIAA account. Correct?
Correct.
You've also entered into an allocation judgment,
Yes.
and this provides for parenting time,
Yes.
and it also provides for joint decision-making.
Correct.
And you understand that if you're unable to make joint decisions together, that you and Hannah would be required to go to mediation.
I understand.
And do you believe this joint parenting agreement is in your children's best interest?
Yes.
We also have a side letter of agreement that is incorporated by reference only into the allocation judgment.
Right.
And we drafted this, and it gives Hannah certain powers to say that on a very short period of time that you may be limited to your parenting time.
Correct.
And this was at the recommendation, and this was negotiated and made through the recommendation of our guardian ad litem.
Correct.
And you believe this is also in your children's best interest?
Yes.
I have no further questions, Your Honor.
Thank you. Ms. Vanderwood, do you have any questions for Ms. Degner?
Yes, just briefly, Your Honor. Mr. Degner, have you disclosed all of your income, assets, and liabilities in this matter?
Yes.
No other questions, Your Honor.
Thank you. And Ms. Vanderwood, do you have any questions for your client?
Yes, briefly, Your Honor.
You may.
Hannah,
Yes,
are you able to hear me?
yes,
Okay. Hannah, so you have been present in open court this morning, is that correct?
yes,
And you have heard the questions that your husband's attorney has asked him today, is that correct?
yes,
And if I was to ask you the same or similar questions, would your answers be the same or substantially the same as your husband?
yes,
Now, Hannah, no children were adopted as a result of your marriage, is that correct?
correct,
And you're not currently pregnant, is that correct?
correct.
Now, Hannah, we have reviewed the allocation judgment together, is that correct?
Yes,
And you understand each and every provision of that agreement?
yes,
And that was worked out over many months with our guardian ad litem, is that correct?
yes,
And today you are satisfied with the terms of that agreement?
yes,
And also the marital settlement agreement that has also been negotiated over a number of months, is that correct?
yes,
And you understand each and every provision of that agreement?
yes,
And you're satisfied with the terms?
yes,
And Hannah, you feel you could be bound by those agreements, is that correct?
yes,
Okay. Now today you are also asking Judge Simonian to incorporate both the allocation judgment and marital settlement agreement into any such judgment that may be entered, is that correct?
yes,
And you have also disclosed all of your assets, incomes, and liabilities in this matter?
yes.
No further questions, Your Honor.
Thank you. And Ms. Bowen, do you have any questions for respondent?
No, Your Honor.
Thank you. The court finds it is subject.
Your Honor, one more housekeeping. I think we need an order to discharge Marjorie's share, and we can send that to you.
She will be discharged as guardian ad litem. Thank you. And in this case, the court finds that it has subject matter jurisdiction and personal jurisdiction over the parties. They were married on May 28, 2006 in the county of Rock, the state of Wisconsin. They've been separated for at least 6 months. At least one of them has lived in Lake County for 90 days prior to filing the petition. 2 children were born to their relationship. Initials HD, born in 2012, WD, born 2016. No other children born or adopted to their relationship. Ms. Degner is not pregnant. The court finds it has jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act. The court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of marriage, and efforts at reconciliation would be impracticable and not in the best interest of the family. The court finds the parties have entered into a written marital settlement agreement, which the court has reviewed. The court finds the property settlement is not unconscionable. The division of marital property and debt and non-marital property and debt is fair and equitable and memorialized in the marital settlement agreement. There's an agreement the parties have on maintenance, and the amounts of maintenance change depending upon when the home is sold and when it's not sold yet. The court refers back to the marital settlement agreement for the precise details of the maintenance, the amount, and the details and when certain facts are triggered in that. It's also a parenting plan of the parties. Parenting plan serves the best interests of the minor children after considering all required statutory factors. Parenting plan contains the necessary dispute resolution provisions and review provisions. Court finds the parents will be able to cooperate in carrying out their significant decision-making responsibilities in the children's best interest after considering all required statutory factors. Court finds parenting time arrangements of the parties serve the best interests of the minor children, considering all required statutory factors. And again, regarding child support, there is an agreement, and the child support will differ depending upon when the home is sold and when it's not, among other things. The court accepts the agreement on child support, and the marital settlement agreement and the judgment for dissolution of marriage have details which trigger the different amounts or the different things which can affect child support. The court refers back to the agreement of the parties and at the judgment for all the details in child support. And Ms. Kreider may, but is, I'm sorry, Ms. Degner may, but is not required to resume the use of her maiden name of Kreider, E-R-Y-E-R, if and when she so chooses. Folks, anything else before the court finalizes the judgment in this case?
No, Your Honor.
What I'm doing, Hannah and Jacob, is I'm now signing the judgment for dissolution of marriage. This enters judgment on the petition, and it formalizes the finalization of the divorce in your case. The clerk will be sending all of you a copy of the completed document. My best wishes to each of you. Thank you, folks.
Thank you, Judge.
Thank you very much, Judge.
And Ms. Carpenter and Ms. Valsamis, I honestly forgot which of you was here first. Who should I be asking next?
Up to Your Honor, I have Malcolm on the call. It is a default prove-up.
I'll be flipping a coin between the two of you.
Your Honor.
I honestly don't know. Ms. Valsamis?
Yes.
Okay. I was just asking Ms. Carpenter, hey, which of you was here first? I honestly forgot.
Both of our clients are here. Looks like we're both ready, so it's up to Your Honor.
Geez, and I don't carry coins with me, so I can't even flip. Well, for some reason, the Malcolm file is on top, and I have no clue why, but I do know it is, so we're going to do that one next. And,
Okay.
Let's see here.
Okay.
And hello, Ms. Malcolm, I am going to just put your full name in there so I know who you are. Good morning, ma'am.
Good morning.
And Ms. Malcolm, I'm going to ask that you please raise your right hand. And do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, ma'am. Please lower your hand. Ms. Carpenter, you are welcome to make a record and proceed with testimony.
Thank you, Your Honor. Judge, this is in re the marriage of Dawn Malcolm and William Malcolm, case number 19D1638. Matter comes before the court this morning for prove-up. Pursuant to Administrative Order 2032, the prove-up is being conducted remotely via Zoom video conferencing. My name is Julia Carpenter. I represent the petitioner, Dawn Malcolm, who is also present on the Zoom call. Judge William Malcolm, the respondent, was personally served with summons and the petition for dissolution of marriage on January the 14th, 2020. He failed to appear, he failed to answer, and on March the 5th of 2020, the court defaulted him.
Thank you. The court has that, and the judgment shall enter. You're welcome to proceed with testimony from Dawn Malcolm.
Thank you, Your Honor. Dawn, you were married to William Malcolm on April the 20th, 2019 in Justice, Illinois. Is that correct?
That's correct.
To the best of your knowledge, that marriage registered in the county in which it took place?
Yes.
You and William separated on or about October the 15th of 2019. Is that correct?
That's correct.
At that time, there were criminal charges pending against William and an emergency order of protection had been entered protecting you against William. Is that also true?
Yes, that's correct.
Okay. On November the 8th, 2019, a plenary order of protection was entered against William protecting you. Is that also correct?
Yes, that's correct.
And is it also true that those criminal charges continue to pend against William?
As far as I know, yes.
Okay. Dawn, you are presently enrolled as a payroll administrator. You are 53 years of age and you are capable of self-supporting. Is that correct?
That's correct, yes.
William is self-employed and he is 61 years of age. Is that also correct?
That's correct.
To the best of your knowledge, is he capable of supporting himself?
Yes, he is.
You and William did not have any children born to your marriage. The two of you did not adopt any children to your marriage, and you are presently not pregnant. Are each of those statements and questions true?
Those are correct, yes.
Okay. You are asking this court to bar William from receipt of maintenance or spousal support from you. Is that correct?
That's correct.
And you are asking, I'm sorry, you are waiving your right to spousal support from William. Is that also true?
Yes,
You are an owner of a home located at 22045 West Calvin Drive in Antioch, Illinois. Is that correct?
yes,
That property was purchased by you prior to the marriage, and you are asking this court to confirm it as your non-marital property. Is that correct?
yes, that's correct.
You are asking this court to, obviously, because it's non-marital, award it to you 100%. Is that also true?
Yes,
You are asking this court to award you all of the personalty in your possession and all of the personalty in William's possession. You are asking the court award to him. Is that correct?
yes,
There are certain items of personal property that William has in your house, and you are asking this court to allow William to come to the house accompanied by the Lake County Sheriff to remove those items within 30 days of the entry of a judgment for dissolution of marriage. Is that correct?
his daughter has already come and picked up all of his property, so
Okay, so there's no personal property of William's left in your home, correct?
that's correct, yes.
William, pursuant to a proposed judgment, is to receive automobiles that are titled in his name, a Cadillac and an F-150 truck. Is that correct?
Yes, that's correct.
And you are asking this court to award those vehicles to William. Is that true?
Yes,
You are asking this court to award you the 2015 Toyota RAV4 that you currently drive. Is that correct?
yes, that's correct.
You have retirement funds. Is that also true?
Yes,
And you are asking this court to award you 100% of your interest in the retirement funds in your name. Is that true?
yes,
In the event William has any retirement funds, you're asking this court to award those funds to him. Is that also true?
yes, that's correct.
You are asking the court to require William to pay any debts that he has incurred in his sole name. Is that accurate?
Yes,
And you are asking this court to, you are indicating that you will pay any debt incurred by you in this matter. Is that correct?
yes, that's correct.
There is one exception to that, is there not? That exception being you are asking this court for the entry of a judgment against William in the amount of $450, which monies represent the amount of money you had to pay to a process server to actually get service on William for these proceedings. Is that true?
Yes, yes, that's correct.
Right. You have medical insurance available to you, is that correct?
Yes,
And should he request it, you will cooperate with William in helping him obtain a COBRA policy on your insurance that he will be solely liable for. Is that also correct?
yes, that's correct.
Okay. Are you asking this court to retain jurisdiction of the terms of a proposed judgment for dissolution of marriage in this matter?
Yes,
Okay. And finally, while it's not in the judgment for the proposed judgment for dissolution of marriage, are you asking the court for the right, but not the obligation, to resume the use of a former name of Sherman, E-I-M-A-N.
Yes, that's correct.
Okay, Judge, I have nothing further.
Thank you. The court finds it has subject matter jurisdiction and personal jurisdiction over the parties. They were married on April 20th, 2019 in the City of Justice, the County of Cook, State of Illinois. They've been separated for at least 6 months. At least one of them has lived in Lake County for 90 days prior to filing the petition. There were no children born or adopted to their relationship. Petitioner is not pregnant. The court finds it's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage. Efforts at reconciliation would be impracticable and not in the best interest of the family. The court finds the parties have entered into, the court enters default judgment against respondent in this cause. The court finds the judgment for dissolution of marriage is a fair and equitable property distribution of the parties. The court has reviewed that. That property distribution is not unconscionable in the division of marital property and debt and non-marital property and debt. It's fair and equitable and memorialized in the judgment for dissolution of marriage. The court finds the petitioner has agreed to waive any claim of maintenance from respondent. Respondent is barred from seeking maintenance. Petitioner may, but is not required to resume the use of her former name if and when she so chooses. Folks, do we have anything else before the court finalizes the judgment in this case?
No, Your Honor.
And what I'm doing now, Ms. Malcolm, is I'm entering judgment for dissolution of marriage. And this will complete the process of divorce for you. You will be mailed a copy of the documents. Good luck to you.
Thank you. Thank you very much.
Thank you, Judge.
And Ms. Balsamis, I think.
Good morning.
I know Mr. Cadena is here, and Mr. Cadena. Good, now we. Good morning, sir. Mr. Cadena, good morning. And can you please raise your right hand for me, sir? And sir, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Please lower your hand. And Ms. Balsamis, you are welcome to make a record and proceed with testimony from Mr. Cadena.
Thank you, Your Honor. For the record, my name is Jenny Balsamas. I am appearing via Zoom this morning. This is case number 19D1531. Also present this morning is my client, Rodolfo Cadena, who is the petitioner. The respondent, Jasmine de Jesus Vera Castaneda, is not present this morning, but has previously filed her appearance as well as the paperwork to have this matter proceed as an uncontested prove-up hearing this morning. Notice was sent to the respondent previously. There has been an allocation judgment that has been entered on this matter on March 5th, 2020, which should be in the court file. Presented to the court this morning is a proposed judgment for dissolution of marriage, which has been signed by both parties.
The court has those documents. You are welcome to proceed with testimony.
Thank you, Your Honor. Rodolfo, will you please state your name for the record?
Rodolfo Cadena.
And you currently live in Waukegan, Lake County, Illinois, is that correct?
Yes, correct.
And you've resided in Lake County, Illinois for over 90 days before we filed your divorce petition, is that correct?
Correct.
You and your wife, Jasmine de Jesus Vera Castaneda, were married on October 24th, 2009, is that correct?
Correct.
And your marriage took place in Waukegan, Lake County, Illinois, is that correct?
Correct.
And your marriage is registered in the state of Illinois, is that correct?
Correct.
You and your wife have been living separate and apart from each other since 2016, is that correct?
Correct.
And you're stating that irreconcilable differences have caused the irretrievable breakdown of your marriage. Is that a true statement?
Yes, correct.
And you believe that any attempts to reconcile with your wife would not be in the best interest of your family. Is that correct?
Yes, correct.
As a result of your relationship with your wife, the two of you have one daughter whose initials are CCV, born 2010, and she's 10 years old now. Is that correct?
Yes, correct.
Did you adopt any children during your marriage?
No,
To the best of your knowledge, is your wife currently expecting a child?
no,
As I mentioned earlier, you and your wife have agreed to an allocation of parental responsibilities and parenting plan. Is that correct?
yes, correct.
And that paperwork was signed by the judge on March 5th, 2020. Is that correct?
Yes, correct.
And based on that paperwork, you and your wife have agreed to joint decision-making responsibilities for your daughter. Is that correct?
Yes, correct.
That document also has in place a visitation schedule for you and your daughter. Is that correct?
Yes, correct.
Do you believe that joint decision-making still serves the best interest for your daughter?
Yes,
And you believe you can continue to cooperate with your wife and follow the provisions that have been outlined in your parenting plan?
yes,
You and your wife have also signed a document that's called the Judgment for Dissolution of Marriage. Is that correct?
yes, correct.
You and I have reviewed that document together, and you understand the provisions of that document, Rodolfo?
Yes,
And your wife signed and initialed, I'll strike that, Your Honor. Your wife has initialed each page on that document. Is that correct?
yes, correct.
And you also have initialed each page on that document. Is that correct?
Yes, correct.
And on page 10 of that document, to the along the left-hand side of that document, that is your signature. Is that correct?
Yes, correct.
And to the right of your signature, your wife has signed that document. Is that correct?
Yes, correct.
I'm going to briefly discuss that document with the court, okay, Rodolfo?
Okay.
So you have agreed to pay the amount of $279 every other week for child support. Is that correct?
Yes, correct.
And that is based on Illinois statutory guidelines, correct?
Yes,
You and your wife have also agreed to equally be responsible for any child-related expenses for your daughter. Is that correct?
yes, correct.
You are going to be entitled to claim your daughter on your tax returns every even numbered year. Is that correct?
Yes, correct.
And your wife will be claiming your daughter on her tax returns every odd numbered years. Is that correct?
Yes, correct.
You and your wife have already divided any personal property amongst yourselves. Is that correct?
Yes, correct.
So whatever you have in your possession, you are keeping, and whatever Jasmine has in her possession, she's keeping. Is that correct?
Yes, correct.
With regards to any debts you may have, you have agreed with your wife that whatever debts you have in your name, you will be responsible for, and whatever debts your wife has in her name, she will be responsible for. Is that correct?
Yes, correct.
You are agreeing to waive maintenance from your wife. Is that correct?
Yes, correct.
And you understand by waiving maintenance today, you cannot come back to this court or any court in the future and request maintenance. Do you understand that?
Yes, correct.
And we are also requesting that your wife be barred from seeking maintenance from you. Is that correct?
Yes, correct.
And Rodolfo, are you asking the court to enter your judgment for dissolution of marriage, which will dissolve the union between you and your wife?
Yes,
Are you asking the court to do that today?
yes.
I have nothing further, Your Honor.
And I just want to point out what appears to be a scrivener's error on page 2 of the judgment, number 7.
Okay, Your Honor.
And you see how it reads, petitioner and respondent stipulate petitioner is not the biological, natural and biological, it says child of VV.
Oh, yes, Your Honor, my apologies. So that is not a scrivener's error, and I can go back on the record if you'd like and explain that.
Sure.
So there was a second child that was born during the marriage that my client is not the father of. That is that child, VV, born 2017.
I understand that, and it looks like, but it says petitioner is not the child of VV.
Oh, I see, Your Honor. I see, yes. It says petitioner and respondent stipulate that petitioner is not the natural and biological child, and it should be father.
Yeah. And that's,
okay.
And the court understands that, and I am just going to replace the word child with father, and I will initial the word father today.
I appreciate that very much, Your Honor. Thank you.
Thank you.
Thank you.
And the court finds it has jurisdiction and personal jurisdiction over the parties. They were married on October 24, 2009 in Waukegan Lake County, Illinois. They've been separated since 2016. At least one of them has lived in Lake County for 90 days prior to filing the petition. There was one child born to their relationship, initials CCV, born in 2010. No other children born to their relationship. Respondent is not known to be pregnant. In the judgment does in fact state that there was a child born that respondent gave birth to, initials VV, born in 2017. And petitioner and respondent agree that he, Mr. Cadena, is not the natural and biological father of VV, born in 2017. The court finds it has jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act. It's been proven that irreconcilable differences have caused the irretrievable breakdown of the marriage. Efforts at reconciliation would be impracticable and not in the best interest of the party. The court finds the parties have entered into a written marital settlement agreement, and the court sees that both parties have initialed the agreement and signed the agreement in this case. The court has reviewed it. The court finds the property settlement is not unconscionable. The division of marital property and debt and non-marital property and debt is fair and equitable and memorialized in the marital settlement agreement. Petitioner has agreed to waive any claim of maintenance. Respondent is barred from seeking maintenance. That is not unconscionable. The court finds that the judgment for dissolution of marriage provides a proper parenting plan for the parties to serve in the best interest of the minor child after considering all required statutory factors. The plan contains the necessary dispute resolution provisions and review provisions. The plan allows the parents to be able to cooperate in carrying out their significant decision-making responsibilities in the minor's best interest after considering all required statutory factors. The parenting time arrangements of the parties serves the best interest of the minor after considering all required statutory factors. Petitioner has agreed to child support in this case in the amount of $279 every other week. The court refers back to the judgment for all of those details. Folks, is there anything else before the court finalizes the judgment in this case?
Your Honor, just briefly, I have also tendered to the court a proposed uniform order for support and notice to withhold income that we would like to also have entered today. Thank you.
Oh, thank you. The court has those and the court will do so. And Mr. Cadena, what I'm doing now, sir, is I'm finalizing the judgment for dissolution of marriage. And since the court has entered that, it completes the process of divorce for you, sir.
Thank you, Your Honor.
Thank you, Mr. Cadena. And thank you as always, Ms. Walsons.
Thank you, Your Honor. Have a good morning.
Thanks.
Have a good morning. Bye.
Oh, now,